Okay, let's dive into this. Welcome to today's Explainer. We're going to unpack a deeply solemn but absolutely crucial case study today on violence, the law, and how institutions function or, well, fail to function when they're really put to the test. Today, we're examining the facts, the historical context, and the legal proceedings surrounding the 2006 Khairlanji Massacre. Our goal with this Explainer is to look at this tragedy objectively, so we can understand the actual mechanics of the law and the systemic response that followed.
I want you to consider this thought for a second. Her crime seems to have been her faith in the Constitution and the rights it guaranteed. It really sets the stage for a profound and tragic irony. We're looking at a case where a woman from a marginalized community lost her life and the lives of her children, not because she broke the law, but precisely because she believed in it. She knew her legal rights, and she actively tried to exercise them.
Section 1. The Khairlanji Massacre. To understand how we arrive at that tragic irony, we really need to start with the facts on the ground. We're focusing our attention on a small village called Khairlanji, over in the Bhandara district of Maharashtra, India, and zooming in on the events that unfolded there in September of 2006.
At the very center of this event is the Bhandara family. They were actually one of only 3 families in the village belonging to the Maharashtra caste. Now, despite being a minority in a village that was dominated by other backward castes and scheduled tribes, along with a small minority of upper caste Kunbis, the Bhandara cultivated their own land independently. The matriarch of the family, Sureka, had built quite a distinct reputation for herself in the area. She was known for flat-out refusing to bow to patriarchal expectations and was highly assertive of her rights. She lived there with her husband Bayalal, their 2 sons, 21-year-old Roshan and 19-year-old Sudhir, who was visually impaired, and their 17-year-old daughter, Priyanka.
Let's move to the timeline and see how this builds, step by step, into fatal violence. On September 13th, a wage dispute broke out between some villagers and a local Mahar policeman. Sureka and her daughter Priyanka actually stepped in to prevent the clash, and then they went straight to the police station to stand as witnesses against the aggressors. Because of their testimony, on September 15th, the accused were arrested. But, exactly 2 weeks later, on September 29th, those same accused men were released on bail. That very same evening, a mob of 40 men carrying lethal weapons marched right to the Bhandara home. The records show Sureka literally tried to set fire to a cowshed just to distract the mob and help her family escape, but it was in vain. Sureka and Priyanka were assaulted, and the entire family, minus Bayalal, who somehow managed to hide behind a bush, was lynched. Their bodies were then loaded onto a vehicle and dumped in a canal. Acting as a witness was the direct catalyst for this brutal retaliation.
Section 2. Sureka's refusal to conform. So, why did Sureka stand her ground in a situation where the power dynamics were so heavily stacked against her? To understand this, we have to look slightly beyond the village of Khairlanji and examine the historical and regional context that shaped her worldview.
You see, Sureka's assertiveness wasn't just created in a vacuum. If we look at the history of Maharashtra, it's built on decades of anti-Brahminical and backward caste movements. This region was literally the staging ground for B.R. Ambedkar's historical pre-independence campaigns for Dalit empowerment. By the time we reached the decades leading up to 2006, this foundation had given rise to groups like the Dalit Panthers, who forcefully demanded civil liberties and democratic rights. This rich regional history of demanding equality is the direct root of what empowered a scheduled caste woman like Sureka to break through those barriers of patriarchy and caste and stand up for a fellow Dalit policeman.
Section 3. The Promise of the Law. When Sureka stood up, she was supposed to be protected by the state. So let's pivot and look at the constitutional framework that was specifically designed for families exactly like the Bhatmanjas.
Now, what's really interesting about this slide is the evolution of legal protection. Article 17 of the Indian Constitution abolished untouchability, but early laws to enforce this were, frankly, considered toothless. Enter the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989. This act was meant to force the state to act promptly against caste prejudice. It didn't just cover physical violence, it effectively expanded the definition of atrocity to include socioeconomic marginalization. It armed the state with real institutional powers and placed a long list of mandatory duties on public servants to protect victims. On paper, this was a robust, ironclad tool to protect the fundamental rights of people like Sureka.
Section 4. The Institutional Cover-Up. Because, as we know, the written law and applied law can be 2 very different things. Let's transition into how the institutions actually responded to the massacre and how the caste-based reality of the crime was systematically stripped away.
Carefully stepping through these cascading institutional failures, a pretty grim pattern emerges. First, we have the police. Despite being informed in real time, the police delayed the necessary medical exams to ascertain sexual assault on Surekha and Priyanka, bizarrely blaming darkness on the official record. And they face no legal penalty for this. Next up, the fast-track court. Because of intense public pressure, the case moved quickly. The court did convict 8 people of murder, but here's the catch. They completely denied the application of the Prevention of Atrocities Act. They accepted the police's excuse for the delayed medical exams and labeled the massacre a simple revenge killing. Finally, the Bombay High Court. They commuted the death sentences to 25 years, and crucially, they upheld the ruling that the incident did not take place on account of caste. So at every single level, the institutions actively erased the caste dimension of the crime.
And this brilliantly illustrates the massive divide between what happened and what the system recorded. On one side, we have the undeniable violent reality. A Dalit family lynched, and the women sexually assaulted for asserting their constitutional rights against a dominant caste mob. On the other side, we have the sanitized legal fiction adopted by the courts, an interpersonal quarrel and a revenge killing where the Prevention of Atrocities Act magically doesn't apply. Even though the victims were Dalits and the person they defended was a Dalit, the judges found no official evidence of caste prejudice.
Section 5, Justice Denied. Let's zoom out to look at the macro-level implications of this systemic cover-up and the final conclusion of the Bhotmanje family's legal battle.
The legal process officially came to an end over a decade later. On May 24, 2019, the Supreme Court of India upheld the High Court's decision in toto. They maintained that the Prevention of Atrocities Act did not apply here. Tragically, the sole survivor, Bayalal Bhotmanje, who had witnessed the murder of his entire family, died of a heart attack in 2017. He was never awarded the compensation outlined under the 1989 Act because the highest court in the land cemented the denial of its application. He passed away 2 years before the final verdict, meaning he never saw true, legally recognized justice in his lifetime.
So the crucial point is this staggering number, 45,935. While the legal battles over Khairlanji spanned over a decade, just trying to prove the existence of caste-based violence, the reality outside the courtroom was escalating rapidly. Reported crimes against scheduled castes in India leaped from 27,070 back in the year of the massacre, 2006, all the way up to 45,935 by the time the Supreme Court closed the case in 2019.
Which leaves us with this provocative question to reflect on. Article 14 of the Constitution guarantees the fundamental right to equality. But when the very legal systems and institutions designed to protect marginalized voices systematically refuse to acknowledge the undeniable reality of caste prejudice, even when it's documented right in front of them, does that constitutional promise of equality remain just a dream? We'll leave that for you to consider. Thanks for joining us to understand the complexities of this pivotal case, and we'll see you in the next explainer.